Good morning. Thank you for coming. For showing up on time. I think the incentive of if you come late, you get stuck in the overflow room watching us all on video was a powerful one. But we're delighted to see so many people here. My name's Mark Lemley, and I run the program in Law Science and Technology here at Stanford Law School. We are delighted to have a really all-star cast of speakers for this conference. This is the third conference that we have run on patent law in conjunction with Samsung Electronics, co-sponsored by Stanford Law Science and Technology Program and Samsung Electronics. As we reached out to design patent law, we also reached out to find some additional co-sponsors for this conference who brought some different perspectives, and we want to extend a special thank you to Google and to Nike, both of whom have also agreed to co-sponsor this conference and have been quite actively involved in helping us make sure we had the all-star lineup we had and had the topics covered that we wanted to talk about. Design patents is one of those things that, especially in Silicon Valley, I think can fly under the radar screen, and a bunch of people, even in patent law, often have gotten by in the past without paying a lot of attention to it. It seems clear that's not possible, and I think the attendance here is good evidence of that. So I'm looking forward to a great conference. I just want to say two more thank yous. One to our conference team, to Trish Gertridge, Jody Carrion, Jackie Del Pozo, and everybody on the team who always make these conferences go off without a hitch. And this, I hope, will be no exception. The other thank you is to Sarah Ryatt, who is our Law Science and Technology Fellow here this year, and who helped put this conference together. So I'm not going to talk anymore. Instead, I'm going to turn the microphone over to our panel leader, James Joe, from Fullwider Patent in Los Angeles, and he's going to start us off on our first panel on design patent prosecution. Thanks.
Thank you, Mark. All right.
I have to get my readers out to read these.
Where's the AV first? We'll have to switch the presentation. Yeah, we'll switch the AV presentation. Well, while we're getting that set up, we'll do the introduction for the panel. To my right is Katie Maxim, who's the design patent manager at Nike, one of our co-sponsors, and what I like to refer to as the queen of expedited design prosecution. Queen. Did I misstate that? Next to her is Alan Datry, who's a senior counselor in the office of the Deputy Director General, Brands and Design Sector for the World Intellectual Property Organization, otherwise known as WIPO, in Geneva, Switzerland. He is directly involved in the formation and implementation of strategic plans and policies with respect to the activities of the brands and design sector. Before joining WIPO, Mr. Datry was employed with the U.S. Patent and Trademark Office, where he held a variety of positions within the examining operation. Can everybody hear me?
How about now? Right. I think it wasn't on.
Name it. All right. Is that better? No? All right.
Here, double mic yourself.
All right. How's this? Better? All right. Sorry about that. Where was I? Alan. He's now with the, he used to be with the USPTO, and what was then known as the Office of the Commissioner for Trademarks and the Trademark Trial and Appeal Board, TTAB, and he's a graduate of the George Mason University School of Law. Next is Brian Hanlon, who's the director of the Office of Patent Legal Administration at the USPTO. We're lucky to have Brian today, especially since he was almost a victim of the sequester. So he's not, so we're very glad that he's here. Prior to his current position, he served as the acting chief of staff for our prior director, David Kapos. He also previously served as the director of strategic planning and management council, and he was also the deputy director of OPLA. Brian was also a patent examiner for the medical devices, so he's been both in the trenches and in management. But in between being an examiner and joining the management of the USPTO, he was also a shareholder at the law firm of Banner and Witkoff. Has a bachelor's in mechanical engineering from Worcester Polytechnic, WPI, and a JD, a magna cum laude from Catholic University. So we're very glad that Brian could join us today. And to my left is Dennis Kraut. He's an associate professor at the University of Missouri Law School of Law. Before that, he was a patent attorney at McDonald, Bowen, Hubert, and Berghoff, if I got that right, in Chicago. In Chicago, I don't get out there that often. And he's taught at Boston University before joining the University of Missouri. He's also the editor of the popular patent law blog Patently O, and which he founded while as an associate at Bowen, or when he's an associate, and right now he's, excuse me, while he's at the University of Chicago, he was a Microsoft, Merck, and Pfizer scholar and a member of the Owens program in law and economics. And prior to going to law school, Dennis worked as a technical consultant for manufacturing in New England as a research fellow at NASA's Glenn Research Center. So we're very glad to have Dennis join us. Before I begin, I want to extend an invitation. We encourage everybody or anybody to ask questions throughout the presentation, so we would encourage questions throughout. So starting off, I just wanted to point out that design patents is a growing area, and this is sort of a historical, like all-time hits are for people who've obtained patents. You know, Sony, Samsung, and Nike are among the top 3. And I think last year, Samsung obtained 378 design patents, and I think they're definitely the leader at this point. But since I know we have a mix of people in the audience today, between people who have been in practice for a while as well as law students, we're going to at least briefly cover some basic points of law just to make sure that everybody's has the same, starting the same page. So design patent scope is primarily determined by the ordinary observer test, and that was set forth by the Supreme Court in Gorham v. White about 140 years ago. And it's pretty simple. It's basically, it sounds simple enough. In the eye of the ordinary observer, would that person determine 2 designs to be substantially the same? But a couple things. One is what's being observed. The focus is on the overall ornamental appearance of the claimed design. So you can't really ignore features if it's part of the claimed design. So all drawing figures in a design patent are used to determine the scope of the claimed design. Next, the next question is, who's the ordinary observer? And it's set forth that it's the sort of a purchaser of things of similar design. So it's not an expert, it's but one who is interested in the subject. And for a long time, the law of design patents was pretty confused, but a couple of years ago, there was an en banc decision by the Federal Circuit in Egyptian Goddess versus Swissa, and that really kind of set the ball rolling for this resurgence in design patents. It reaffirmed that the ordinary observer is the test for determining the scope of a patent, and they gave it an additional gloss, which is it's the observer with reasonable familiarity with the prior art. So it's not evaluated in a vacuum, but it's part of it's part of what the ordinary observer knows. And part of that reason is, as the ordinary observer with knowledge of the prior art, will attach differences, depending upon what's already known in the art. So some things may be more important or less important depending on what's shown in the prior art. And this is illustrated in the case in Egyptian Goddess, which dealt with nail buffers. And right now, we have, this is the patented design. And we had an accused product, which was very similar. But what happened was there was prior art, which seemed to divide the world into designs which had 3 buffing pads 3 sides for buffing and those which had 4. And that was really the only difference between those 2 products. Now, there was also expert testimony that supported that. That's in the market. There was like basically 3-sided buffers and 4-sided buffers, and basically never, for the consumers, for the market, never the twain shall meet. It's always, if you want 3, you buy 3. If you want 4, you buy 4. And based on that testimony and the prior art, the court found that there was no infringement. Now, for patentability, the design must be both novel and non-obvious over the prior art. And the anticipation analysis under 102 is in view, takes the ordinary observer test. But for the obviousness analysis, it's a little bit different. Right now we have, it's whether there's an ordinary designer aspect to it, which is different from the ordinary observer. That comes into play in how you combine the art. So it's not the ordinary observer, what the ordinary observer would combine, but an ordinary designer, which is closer to the typical person of ordinary skill in the art on the utility patent side of things. But once you make that combination, then you sort of change your hats and then start off determining patentability in view of the ordinary observer test again. So it's a bit schizophrenic, but that's the way the law is set forth right now. It seems to make a certain amount of sense to me, at least. And after Egyptian Goddess, there was a case concerning the Crocs, which, I have to say this, my wife says that they're the ugliest shoes she loves to wear. So right now, there was a case with Crocs and a competitor. The Federal Circuit found that the outward appearance, basically the uppers of the shoes, there was substantial similarity. But they found that there was an issue of fact with respect to the insole. And the court determined that, actually remanded back to the district court to determine, whether the insole pattern, would bar a finding of anticipation or obviousness. So that's something to consider, that, this part here, the insole, that was the question that the court found that the district court hadn't really fully considered and remanded for further consideration. Okay. And although design patents are often considered for consumer products like shoes, they also cover computer icons and graphical user interfaces, or GUIs. And this is a design patent that Google obtained a couple years ago. And you'll see it's basically their home page. And if you notice here, everything is dashed out for the name Google. And the reason they did that is because when something is in dashed lines, it's not considered part of the claimed invention. And so basically, if they wanted to try to have the ability to cover somebody who tries to copy their web page without using their name, I guess. So Yahoo basically can't revamp their website. All right. For another example, to illustrate the use of dashed lines, here's 2 design patents: Design Patent A and Design Patent B. Right now, and we have a sort of a hypothetical design. There's the third design on the right. Now, if one were to go into the market with that design, I think even though there's never any such thing as a slam dunk in the law, the hypothetical design here is, for design patent A, it's the closest thing you'll have to a slam dunk for design patent infringement. So there's a decent chance of getting summary judgment of infringement for that case. The different story for patent B, design patent B. I think because everything in that drawing is drawn in solid line, that means nothing has been dashed out. That means you look at all of the features to determine the scope of that design patent claim, because the claims in the design patent are determined by the drawings. So you have to look at everything. So even though it has the same distinctive guitar neck, which is dashed out in design patent A, you have to consider both the neck and the body. So for that reason, I think there's still a case to be made for infringement of the design over patent B, but I think summary judgment is really out of the question with the bottle. And it started off on the left is the parent application, and there was a continuation filed later on which tried to claim priority to the earlier filing date of the parent. And you'll see what happened. What they did was they had added a dashed line right here to create this trapezoidal area. And the issue was in litigation was it was really a written description question, and it's whether whether your observer would recognize that disclosure, from the original application. And what the Federal Circuit found was that the disclosure did not distinguish that trapezoidal area from the rest of the design. So they felt that it just basically sort of cut that out. There was no reason to draw a line there, and hence they upheld the rejection. Even though there was, again, this is an example of what was fairly common practice, where during prosecution and subsequent applications, you sort of slice and dice a design. At the top, everything is pretty much drawn in solid line, and then for a subsequent application, they would then dash out the substantial portion, the back end of it, and the top of it, top of that design, and then in another continuation, they would then dash out everything but the bottom. They'll dash out the entire bottom and then leave the top portion in solid line. So this was a fairly common procedure, which has now, I think, come to question. During the appeal, in Owens tried to rely on In re Daniels, and in this case, the design on the left was the parent, and the design on the right was the subsequent continuation, and that was held to be appropriate, that you could still claim priority going back, because it's just removing that one design element. But this is also something special. The court looked at the MPEP, which is, as we all know, the sort of like Bible for patent prosecution, and they noted that the guidance provided in section 1503.02 was ambiguous, and basically said that it just didn't provide sufficient guidance, and that's basically out the window now. The court then endorsed the position for the PTO in its brief that a unclaimed boundary line may satisfy the written description requirement if it makes explicit a boundary that already exists but was unclaimed in the original disclosure. I think right now it's a little unclear exactly what the scope of the written description requirement is. I do note that a couple of years ago, the USPTO did promulgate some guidelines on the written description requirement for utility patents. And I posed the question to Brian whether there's any plans of doing something similar.
It is something that we're looking at, but as this case just came out, the time for requesting rehearing for the case hasn't expired. So as that time period is ticking and moving forward, we're considering what changes we need to make and the avenue that we'll use to make those changes. Okay,
Brian, I also believe that isn't there like a process of revising the MPEP underway just in general?
Yeah, the MPEP is being revised, especially because they're attempting to put in the AIA provisions for the MPEP. But it's actually a very long process. As you can imagine, it's a very detailed process to do that, as well as we have new IT software that we're working with. So it's not something that necessarily moves very quickly, but we're attempting to develop a new process to do the manual so that it can be much faster.
Right. Okay. So the ink's not dry. The ink's just dry in this opinion. So I think we'll have to wait and see where it goes. Next, and I believe the next panel will cover this in more depth. But I just wanted to just touch upon the questions of functionality, because a design patent is not supposed to protect how the function of anything, but really just it's the ornamental appearance or its look. So in this case, sort of illustrates that, because you have two products which would seem to perform the same functions, but which have obviously a different appearance. And in this case, the Federal Circuit found that there was no infringement. On a related note, I know it's in the Lubitani case from the Second Circuit, I know there was a lot of talk about aesthetic functionality for colors. And I point this out because there's a lot of overlap between design patents and trademarks. And one thing that's kind of interesting to note is that design patents can also claim color. And if you look right here, I've got a couple of examples. The one on the left is a golf club, and it has a red stripe in the inside of it. And that's in the shaded portion. So you can do that if you can establish or assert that the color is a critical part of your claim design. So, and this seems to be a pretty sort of standard example. I don't think the doctrine of aesthetic functionality for color is going to really come into play here because it could be any different color. So that's probably in the clear. For the case on the right, it's entitled Red Velvet Cake, and it's a color photograph. I have to say one thing. I got to think that for a red velvet cake, the color red is, you probably have a good shot, at least one of your better chances of establishing aesthetic functionality for a red velvet cake. I'm thinking that it may have been better. They may have been better off just going with the standard line drawing. I'm not sure if the colors really add that much to this patent, but so be it. I just want to give you some examples of where color can be introduced into a design patent. As I mentioned, there's an overlap between design patents and trademarks. I think one good example here is the Apple iPod, where Apple filed for a design patent and then subsequently filed for a trademark registration. And in this case, they had a lot of secondary meaning that could establish that the trade dress had, become known, associated with Apple in the marketplace. And you'll note that it's a little faded out here, but that the drawings are pretty much identical, except for some surface lines. They are the same drawings between the two. On a slightly different note, we have a couple years ago, there was some litigation with Paris Hilton over some shoes that she had designed. In this case, there was a design patent for what they called a shoe sock, and it had a little heart emblem near the bald foot. And Paris Hilton had a line of shoes which had a heart on the bottom sole of the shoe, right there. I've been told that the reason function for that heart is so she can dance all night long. I'm not sure if that's really going to do very much good for a functionality defense, but I thought I'd pass that along. So the complaint alleged both design patent infringement as well as a trademark infringement under the Lanham Act. But there was no trademark registration, so they would have to establish secondary meaning. But they still had unregistered trademark rights to assert. But there would be, there's issues of proof involved and whether the person could establish it. But even though that would be traditionally how you would think of this case, the fact that one had a design patent, I think, definitely strengthened their hand in settling this matter. So. And I think even though there's a lot of overlap, there's a couple things to keep in mind. For trade dress, so long it's still, in use in commerce, the length of its protection is potentially indefinite, whereas design patents will expires in 14 years after issuance. But during that 14 years, that may give you the time necessary to develop secondary meaning in order to have trade dress protection. So that's sort of like a quick run through of some general design patent concepts. For design patents, I think one thing that's kind of interesting is that it has a very high allowance rate. I think something close to 90%, which is actually sort of like the inverse of what you find. Well, I shouldn't say that. For Right. For utility patents, the feeling is almost everything is there's a high level of rejection in the first office action, and so I don't know what the numbers are, but it's probably close to this in terms of you'll get a first office. Your first office action is typically a rejection. Doesn't mean that you're not going to get an allowance, but usually the first cut is defined as rejection, not defined as allowance. And I think this is some research that Dennis had done back in 2009, and if you want to, I think I'll pass it over to.
Oh, sure. So it's absolutely true that for the past decade at least, the allowance rate for design patents has hovered right around 90%. At some points, it's dropped as low as maybe 88% over the year, and some as high as maybe 92%. But it's been right around that rate the entire time. What I did for this to make this chart was download file histories for about I think this was about 20,000 design patents that had issued over the past several years, and for each of those file histories, looked to see whether they had been rejected, and then for the ones that had been rejected, looked at the reasons why they were rejected, and so you can see the vast majority had no rejection at all. So although design patents go through an examination process just like a utility patent, James is exactly right that kind of the rejection rates are flipped, and that if you have a utility patent, on average, I think about 85% receive an initial office action rejection, and almost all of those initial office action rejections are based on prior art grounds. That is, they lack novelty, or they are obvious, right? There's an argument that they're obvious. In my study, I found that only 1.2% had a rejection based on prior art. Now, there's a big caveat here that there's a little bit of problem with the data in that, unlike utility patents, design patents are not published, and therefore, if a design patent is filed, rejected, and abandoned, then we never actually know why it was abandoned, because those files are kept secret at the patent office. But we know only 10% are abandoned, and so at most, kind of 11% of applications receive a prior art rejection. But I would suspect that in reality it's more. Right? If we consider the abandoned ones more as well, I would suspect it's about 3% that actually receive a rejection associated with abandonment.
Where do you put an ex parte quail action that wants you to make certain drawing changes? I feel like sometimes I get those. They could have been a 112 rejection, but maybe the examiner being nice and just making you fix some things. Do you consider that rejection?
Yeah. I don't actually remember where that fits here. So an ex parte quail action, right, in a design. So typically in design patents, if there is some amount of right, if your drawings for whatever reason the examiner feels are not entirely up to standard, perhaps there's some fuzziness in the drawings, perhaps they don't show the views as well as what might be show the various views with a level of specificity that the examiner would like. Right, in those scenarios, the examiner typically rejects under Section 112, which is right. So there's some kind of indefiniteness in the claims. Right now, my 112 rejections here are also the same as the Owens case. This also includes the Owens case where there was an initial design patent that was then amended, where the drawings were amended to somehow expand the scope. So and then the examiner would reject those basically for adding new matter, as well as under 112 for lack of written description or lack of enablement. And so those are 112. I can go back and figure out where I put the quail actions, because I think they are in here, and so they must be under 112, under my category of 112. Right, and then so easy enough. what this tells me, what I wrote about when I found this graph was that in a large way, in reality, although we call it a design, although we talk about design patent examination, really it's a registration system where we do actually look at.
You know Brian's down the hall.
I do.
Right down the table.
Right. We call it I would call this based upon almost based wholly upon these stats and the vast difference from the utility patent system. This looks a lot more like a registration system that looks for technical defects in the application, but that doesn't, to any serious extent, try to figure out whether these applications are actually novel and are actually non-obvious. What? Is this Perry talking? Okay.
How do you conclude?
Okay. So my conclusion there is it's the kind of a conclusion a jury would make based upon It's not a jury a philosopher would make with 100% accuracy. That this data necessarily shows that. Okay.
No further questions.
Okay.
I just have to interject and say that there are some 100+ examiners at the U.S. Patent and Trademark Office, as well as myself and everyone else, who would disagree that this is any type of a registration system. It's a significant examination system.
Okay, and
I respectfully disagree.
But now to say that it's a registration system. So first of all, the 112 rejections and the double patenting rejections. And the non-statutory subject matter rejections, are all extremely important types of rejections and are important to have in a system. And so there's a lot of work that goes into even those elements. And so to say, so this is not a registration system where you just pay the money and you have it. Or like the copyright system where as soon as you put it into a written form, you've got at least some form of copyright protection, And so we could call this a substantial registration system.
Well, and as a business person, I'm going to take just a bit of exception to what Dennis is saying also, in that we work mightily to ensure that any application that we put before the Patent Office is thoroughly researched. We know our industry, we know our prior art, and we ensure that those applications are in as pristine a condition before they hit the Patent Office as they possibly can. So I feel that that's something that's incumbent upon, obviously I'm in a team with my outside counsel, and I think that that's something that's incumbent upon the business to ensure that this process is smooth.
And we'll get a question in just a second. So in part, so Katie is so one kind of fact that totally goes against what I'm saying is that if you look at court decisions, design patents are almost never found invalid. And so that's a suggestion that that for whatever reason, maybe it's because of some pre-filing self-elimination, or maybe it is that maybe it is that all these that they just don't need to reject it because. I don't know, but for whatever reason, these are not getting invalidated, and it might be because the law of invalidation, it's really hard to invalidate them, and we'll get to that. Is that that's the academic point of view that this has gone that far. But so that's on one side, but on the other side of this, I know that so the top companies that James talked about, so Samsung and Nike and others. Do substantial pre-filing activity to make sure they're filing high-quality applications. But there are also, every year, thousands of design patent applications that you would call very low quality from independent inventors who have not paid attorneys to examine these, who have not done substantial pre-filing work, and those also those are flying through the system in the same manner. Okay, and
I want to see. I think that the premise of this comparison doesn't really recognize the nature of the design. So if you were to design on your own an automobile, you went to you did all your research, you created a nice aesthetic, pleasing automobile on your own. Odds are it's going to be a original. That's the essence of the design. Unless you're copying somebody else, it's going to be original. That's the essence of it. If on the flip side, you're creating an improvement on the braking system of an automobile, you're going to run into tons of prior art. The odds that the improvement of a utility one is in the prior art, it's going to be 20 times higher. And so that easily explains this. And you did point out the fact that the ones that are rejected aren't in the study.
Right.
And because the difficulty in amending post-filing, if it turns out that the examiner finds something close to your automobile and issues a rejection, there's not a lot of arguments you can make. If you're going to get a 102 rejection or a 103 rejection, they're really close, you're probably going to let it go, because even if you get the design, your scope is going to be really, really small, because it's saying the prior art's that close. So, yeah, if there's 10% of the stuff that got rejected and never issued are not in here, then the numbers make a lot of sense. What you're seeing makes sense, and I wouldn't call this a registration system at all. I would say it's the evolution of how designs are created and what designs are.
Right.
Well, then actually, this.
I think that's right, but I think
Okay.
it's more fundamental. Maybe it's because human perception is well able to discern visual differences, so that to ordinary observers there are visual differences, and maybe human perception is adapted to identify similarities in conceptual areas, which is what you're doing on the utility patent side.
I think both of those are fair points, and help to explain this data.
We can't ignore the fact that we've got a different set of legal rules for determining the validity of a design patent than we do for determining the validity of a utility patent. Right? If you take an obviousness doctrine that looks nothing like the post-KSR utility patent obviousness doctrine, it's not surprising that even if you had the prior art in front of you, you're not going to see as many rejections.
Right. But
maybe that's fine, although I guess where I get nervous is when we then get off that same path when we get to infringement and say, okay, you're right, everybody comes up with independent designs, but instead of just prohibiting copying or just prohibiting somebody who's done a virtually identical design, we expand the definition of infringement rather than.
Well, actually, I think one thing to consider is, sorry.
I think, Professor Lundy, the interesting point to follow up on the case law, what are the tests for validity here? I mean, first keep in mind that this is a relatively narrow law. Okay? So you're going to find a piece of prior art that falls on all fours, right down that piece of prior art, it's difficult to find. But look at the year up there. It's 2009. Well, what happened after 2009? You got the International Seaway case, which now has taken, at least on its face, has taken the test for anticipation, which was previously required that it had to be identical in all material respects of the served by the Federal Circuit. And now they've turned the anticipation test, at least as far as the courts are applying it, into the ordinary observer test. It's going to be used for anticipation. So I'd be very curious to see if you could update the statistics to see where we are in 2012, if we're seeing the same type of rarity of a 102 rejection. In fact, the law has seen somewhat of a change in the interim.
And so I'm sorry, so I have I have a small sample, but I didn't want to bring it, but I don't think it's really changed. Okay. Now, so one thing we can agree on, I think one thing we can agree on is that that at least whatever we call it, there's fewer, right? It's much less likely that any design patent application is going to get a rejection, right? And then compared with the utility patent, and this is just some kind of simple data. So this is again of ones that issued, right? So 25% of my sample had an initial rejection, and then for the most part, those were able to overcome the initial, right? So 4.1% were finally rejected, and there's very few appeals in these cases. And it may well be that part of the issue here is that when there is a prior art rejection in the past, what those prior art rejections have been ones that are right on, and so there's no and so the applicants figure that out and just stop.
The problem with applying international C-rater and that it relies on the quality of the prior art that the examiner has to compare. You know, it's really on the prior art and the claim design. And if the PTO can't effectively search for pictures, then you're relying on the applicant to provide the prior art. If applicants aren't doing searches because they're not required to, then I think that International Seaway is very difficult to apply that at the PTO because, you know, if they don't have good prior art, then they're not going to be able to make the right decision.
I think under Egyptian Goddess, you know, one thing to keep in mind is that for crowded art, you are probably more likely to get an allowance, and sort of the flip side is that it's going to be harder to prove infringement because your scope of your claim is going to be narrower. So I think that may be something to keep in mind, is that you do have to look at the scope of the patent, of a design patent. You know, is also a function of the art, and in a crowded art, you know, these small differences, which may not matter where you're sort of like the first mover in a design area, those smaller differences may be the distinctions. I mean, in that International Seaway case with the Crocs, you know, it was the dimples on the insole, which was an issue that the court felt could be a basis to maintain validity and avoid a rejection, or not. It wasn't a rejection in that case, but for validity purposes. So I think that's something that we have to keep in mind. It's not in a vacuum.
It's just if your searching is based on words to look for images, I think there's just an inherent error in that process.
And in reality, right, I don't think that, I think design patent examiners do some amount of keyword searching, but the patent office does have excellent facilities for patent examiners to do a broad search and then basically flip through images at a very rapid pace, right? And as the comment suggested, right, that folks who are practiced at doing this can do a pretty good job of flipping through images to find things that are quite similar. And the caveat, the only problem with this is that approach relies upon finding this prior art in prior patents and having a good classification system that helps them find that. And that system doesn't work well for what you'd call non-patent prior art. And so there are those limitations, and certainly I think Google is here. We do need a better image search technology, and so go ahead and do that. And I just also should make a caveat. Although I like to call it a registration system, I'm not against having a registration system. I'm not saying that we need to ratchet up this examination because we've got so many improperly issued design patents. I just say, well, we should call it out. And the problem, right, the obvious problem with calling it a registration system is that the next step means that folks will want to take away the presumption of validity that's normally associated with the patent. And so that's an issue that would need to be worked out if we had a registration system. Now, so one other, just the second image that I'll just mention, and we'll talk a little bit more about timing. And so this second bar chart says average months in prosecution. Obviously, the first line, the bar on your left says applications that were never rejected. Those right back in '99, those took about a year, and ones that receive a rejection take a little longer. The timing today is roughly the same as it was in 2009.
Yeah. Okay. And you can also see from the chart that if you're trying to get an application out as soon as possible, it behooves you to avoid getting rejections and to try to file as high quality application as you can. And that's for expedited examination. I'll pass it along to Katie, to the queen of expedited prosecution.
Yes, kind words he says, but the truth is it's just practical matters. I was going to pass along some best practices that we engage in that allow us to have the rapid prosecution and issuance time that Professor Crouch recently commented on in his in his blog. Expedited exam, we do use it quite a bit. The facts are that we have an industry that turns over very quickly, and our products are in the marketplace and out. And a year's pendency for an application is not something that is realistic for a company like mine to endure. So in light of that, we have worked in concert with our outside counsel to figure out what can we do to take that down to the shortest amount of time that is possible. And certainly expedited exam is a tremendous tool within that. But it's not the only thing that we utilize. We also are experts. My part of the team that I form with my outside counsel is that we are experts in our prior art. Not only do we know our competitors, not only do we know what our competitors produce and what their products look like, but we also study other industries to ensure that we are up to date on what they're providing. As much as I know athletic footwear, I know fashion footwear in addition, and keep track of that. Also, we know our own prior art, which for a company like mine that is as prolific as it is a very important factor. And we keep track of that, and we ensure that every time that we come up with a new design, not only do we look outwardly, but we look inwardly. In addition to that, we are experts in knowing our drawing formats. I would like to take credit for this. I can't. My outside counsel is the one who has educated me. But we are very meticulous in what we provide in the way of a drawing format. And we study that continuously. Yes?
What exactly do you mean by a drawing format?
The way in which we provide the drawings, the way that we use phantom lines, where we include solid lines, where we include phantom lines, where we include shading, what type of shading we include, whether we include the surface or we have it be more generic for any type of surface. These are all things that we spend a considerable amount of time studying and reviewing with outside counsel before we file any application. And not only do we do that for our US applications, but we ensure that we have that same meticulous nature for anything that we would foreign file. And spend a great deal of time, anytime that we are going to foreign file, we spend a great deal of time studying what that market is about, reviewing litigation, seeing where there has been litigation, what's been successful, what hasn't, where there's been invalidity and where there hasn't been invalidity. So that is a very important part of our overall practice. And then summing this all together, if we do get one of the few rejections that Dennis was noting are issued by the USPTO, we pay great attention to those. We try and learn from each and every one of them and from any conversation that we have with an examiner to really take apart what they're telling us and ensure that we take that to heart and we incorporate it in our future practice. Those are great nuggets of learning whenever they come down the pike for us. And we ensure that we do incorporate that into anything that we do.
All right. Any more questions? Oh.
What's the split for Mackie of utility versus design patents?
We have approximately just over 10,000 design patents around the world, design patents and registrations around the world, and we have about 3,000 to 4,000 utility. So it's design, as you might expect from the nature of our business, it is design patent. Yes?
With an expedited examination, about how long does it take for patent issues?
Obviously, it's greatly varied dependent on subject matter and what we're doing, but as Professor Crowley recently pointed out, we can get issuances as quickly as 3 months. And we get notice of allowance in potentially as little as 8 weeks, depending.
Yeah, this rocket docket, we call it, right, it's often called the rocket docket, and it's a separate procedure, and there's different rules associated with it as compared with expedited examination for utility patents, and the fee is substantially less. I think it's $900 for a large entity, or half that for a small entity, and now a quarter of that for a micro entity. And these are, right, and so there is this mechanism that if you want it fast, and you file a quality application, then you're probably going to get a rapid issuance, right? And with kind of an ordinary product you might be putting out on the market, that kind of timeline is one that is right for many products. That's a timeline that can work for you, so that you can have a design patent that issues around the time of the product release. Excuse me, I'm not going to answer. So
Right,
That's great.
and that's absolutely correct. And the last thing I was going to say with regard to all of this is that we also try to be meticulous in studying our designs and seeing what really needs to be included within the claim. Not every line, not every portion of that design is something that needs to be included in that. And so, that, again, that's incumbent upon me as the business person to really look at that, look at what the essence of the design is, and that is what we include within our applications as opposed to a direct copy of what that product embodiment might be.
All right, thank you, Katie.
All right,
Yeah. Yeah, so
there we go.
Speaking about sort of pendencies and timelines, I thought we could take a little trip in the past. Back in the 80s, Paramount Pictures was filing a lot of design patents on basically anything and everything Star Trek. And it started off in the early 80s. It was taking them, as you can see on the left, it took them about 2 years to get a design patent on the Starship Enterprise. And towards the end of the decade, it took them 3 years to get them a design patent on the next generation. And around that time, they just stopped doing it. I once ran into somebody, an attorney who works at Paramount. I asked him about this, and he had no idea. I don't know if anybody's still at Paramount who remembers what the thinking was behind this. But let's see.
And obviously, right, this would cover both actual starships and
just toys. Just toys.
No, but right.
Very good point.
But I will notice, 2 plus 3 is 5, so it's a 5-year mission.
Yeah. Now, and so design patents, in addition to kind of the apparel area, design patents and device area, design patents have also become very popular in the field of automotive. And folks get patents covering this entire shape of a car, which would both cover the car and kind of a model of the car, and even more than the design of the entire car, parts of a car, such as the fender of a car, and that gives those companies control over the spare parts market, and so that if you bang up your car and want to get it repaired, right, you can't just buy a knockoff version, at least for 14 years, that is during the term of the design patent. And over the past several years, almost on an annual, I guess every 2 years, there's a reintroduction of a bill in Congress that would essentially exempt spare parts from the design patent context, but that's never gained any serious traction.
Thank you, Dennis. So looking at these designs, this is another chart that Dennis prepared a while ago, showing the pendency or issue for issuing design patents. Taking our prior examples, we have the Enterprise taking 2 years around the early 80s. Next, the next generation, we're creeping up on 3. But after that, the pendency rate was just dropped like a stone, and it's pretty much now, as Dennis says, between a year to a year and a half on average. So we're now in the iPhone era, where that's the standard. I think I'll turn this over to Dennis again.
And so these are average pendencies. The average is a little more than a year still today. And just as a caveat, so the averages in terms of pendencies of patents, including design patents, are always skewed a little high because there are always a handful of patents that have a really long pendency. That is, they take a long time from filing date to issuance date. And so the median pendency now, I think, is a little bit under a year. So that is, if you pick any patent at random, odds are it probably took less than a year to get through. And then if you pick one of these that went expedited, it's going to be substantially less than that. And here, right, we have
the rocket dockets.
Doing it. Or we can.
It's both.
Well, I think we already covered this.
Okay.
Unless anybody has any questions.
But it actually goes to the woman's question about the average pendency in the rocket docket. You can see on the far right side that it's been around 8 months for the last few years.
And that says the average, right? The whole average.
Yeah.
Right. Oh, sorry, there's a question back.
So I see it just came up on your second slide.
Next slide.
Isn't total backlog likely to be a function of I wonder what that chart for enrollment volume
So the question is, what's the relationship between the backlog and the pendency? And I think they're obviously related. And I think right now, kind of the bottleneck, if there is one, is kind of the number of examiners, the number of design patent examiners, and that number has hovered around 100 for maybe the past decade or so. Although the patent office could force them to do more work, that would be hard to actually get that type of thing through. So that's that's almost a fixed bottleneck where they could hire a few more, and that would increase throughput. This chart here shows the backlog has been kind of increasing because the patent office, I think the 100 examiners can issue maybe around 25,000, can get through maybe about 25,000 a year, but for the past couple of years we've had more like 30,000 applications, and so the backlog has grown. And just there's a delay in terms of the pendency numbers because the backlog, because they're still working on relatively recent ones, but if this backlog continues to grow, then the pendency will also start going up as early as this year and then into next year. And so the patent office has to make a little bit of a move, but the good thing is that it doesn't take, if they hired 10 design patent examiners, that would turn this around. That would be sufficient to totally turn this around. And so there's a little bit of management in there, but that's a fairly minor personnel issue that I think Brian's going to be able to handle.
I've taken over HR as well as 2,900. But yeah, Dennis is right. And also I think that as the rocket docket is more attractive also, some of the examiners' time is dedicated to the rocket docket cases, so they're maybe not getting to some of the others. So some of those that aren't on it might tail up a little bit. But as you said, we've had the 100, we've added a few over time. But there has to be, for a business model, obviously, there has to be some amount of backlog because we have to have work available to the examiners to do. It's just like in the utility world, the 700,000 was too big a backlog, but there still has to be some backlog so that folks have cases to work on when they're ready to examine. So.
Well, I will add this, for hiring new examiners, it does take them a little bit of time to get up to speed, probably about a year or two, because when they come in, they're green, they're not as efficient as they will be in a couple of years.
Right.
So there is a certain amount of lag. Even if you do go on a hiring spree now, which with sequester, I'm not sure if that's even possible, but it would take them a little bit of time to sort of get up to speed so they're at full efficiency.
And the one thing I think would be important, and later on today, there will be more discussion about this overlap between trade dress protection and design patent protection. I certainly think that the office should take that into account and have much more crosstalk between trademark examiners who are doing trade dress examination and design patent examiners, and in that sense, we could, if you're thinking about managing the system to make sure that everybody has work to do, if you get done with all the design patents, they can do a little bit of trademark work. It would be my hope that the patent office could be a little less risk averse in terms of the backlog and say, okay, we'd be fine if it was just a 3-month backlog, and go with that.
Okay, we have some questions in the back. Yes.
Yes, yeah. Well, that's a good point, because the more senior you are, the requirements of the production system are that you produce more, so you examine more applications. But I do think that there's a higher retention rate in design than there is in utility. Yes, definitely.
Do you know what the average
I don't know the average or the retention rate specifically in design.
But there are dozens of design examiners who have been there for more than a decade.
Yes. Oh, yeah.
And right. So.
Yeah. Yeah. So you're a gentleman.
Yes, there's a gentleman in the back.
I'm not sure about design examiners coming from the utility side of things, because a lot of the design examiners that I know and the people that I know we've hired have had some experience in design, have had some art in their background, or have had some industrial design in their background. I'm not familiar with design examiners who have come previously from the utility field. Yeah. I honestly, I don't know every person in the design group, so I can't tell you exactly what their background is, but I know that from speaking to the management in the TC that a lot of their examiners and what they look for are people with that arts type of background, because they want to be able to understand the figures, so forth.
All right. We have another question? Oh, sorry, sir.
I have a question, just maybe off topic. Is there a symmetry between prosecution and litigation? What I mean is, if 90% of design patents are accepted, with the current system which takes into account everything, law, process, perception, technology, everything, would it mean that 90% of litigation cases are thrown away? So 90% of patents are found non-infringing?
I don't know if I would say that there's that kind of a correlation.
Well, and in fact, so the answer is no, that 90% of the litigations are not thrown out. And there's just there's too many factors in between, because for the most part, if somebody has a patent right that they know is worthless, they're not going to file a litigation case, right? And so the stats won't even. They won't even play out. But we're going to, we have subsequent panels on design patent litigation that are going to be talking about, to some extent, the issue and the difficulty in invalidating a design patent and the ease in certain cases of proving infringement. And so there's, although we think about symmetry between obviousness and infringement, but it's not, in the process, I don't really think it's there for design patents at this point.
Oh, in the back, yes.
Thank you.
Physical product versus GUI, graphical products. And second, related to that, coming to the office here, are there going to be more comprehensive guidelines of how you examine graphical user interface type applications? Because I'm finding out in my experience that examiners are struggling.
I have to pass that along to Brian.
Yeah, to answer the second one first, it's something that we are continuously working on. And as you passed it off, there was someone to my right who laughed because he's a gentleman who's spoken to us a number of times also about the issue. So we are aware of that, and it's something that we continuously meet with the design group and the management of the design group to discuss the issue about that. With respect to the office, I'm not aware that we keep statistics specifically, but it could be, if somebody wanted to do the study, it could be determined between the two, because somebody could just review the patents that have issued or the patents in the particular class and subclass where those would be versus the remainder of the design patents that issued. But that's not something that we keep as a statistic.
Maybe some of the project for Dennis.
That's why I was throwing that, yeah.
All right. This is really just just the numbers behind the prior graph.
Right. And the one point of that is that over the past decade, design patent applications have almost doubled. And so these are, but that's also true with utility patents.
Right. Yeah. Next, and we spoke about this earlier, that the number of design examiners has been about 100. There's been a recent uptick, but I think that's just some numbers behind what we're talking about. Next, this is a chart that Dennis had put together. So this chart talks about the timing of first office actions of the merits, and I classified the different sections of the PTO into different color codes. And the point for today is just design patents are the design patent group, are the fastest of any group at the patent office. And so although I complain about a year being too long, it's also it's faster than anything else the patent office is doing. Next, I'm going to turn this over to Brian, but I noticed that for ex parte and inter partes re-examination, there was really no activity on the design patents until last year, and then you have 8 and 4. So I passed it along to Brian to discuss this. Well, I mean, I think there's also...
Yes.
Well, I mean, I
but
think
the issue is, we were talking about the fact that, as many of you may know, that there's a unit within the Patent Office called the Central Reexamination Unit that handles IP and inter partes and ex parte reexaminations. But the re-exams for design stay with the design group, and then they work with the folks in my office and the folks in the CRU to do the reexaminations. Yeah.
And Brian's now going to go into depth on the AIA.
I'm going to try and be a little quick here because I want to give Alan some time to talk about the Hague, which is probably something that's as important with its future coming to the office as the AIA is today, since I'm sure everybody's been affected by the AIA already since everything's in place, so you probably know everything I'm going to tell you. But a couple of things that I just want to mention to you that are up here in the timeline. You can see all the different things that we've done since September 16th of 2011. But a couple of things I want to bring to your attention that might be a little different for design than in utility is, first of all, the prioritized examination that went into effect in September 26th of 2011, not available to design patent applications. So that's, as we talked about a little bit earlier, Designs has the rocket docket, so that's your avenue to expedite the prosecution of your application using the rocket docket instead of prioritized exam, and it's significantly less expensive, and $900 for other, for a regular entity compared to, say, $4,000. Another one that went into effect in September of 2012, the third-party pre-issuance submission. This is something that, while it's available to design patents, it might be something that's not that effective or that used in the design world, because this is usually something, if folks aren't familiar with it, it's the one where the third parties can submit prior art into applications. And usually I think people are going to learn about the application that they're interested in providing the art in via the application's publication. Well, since design patent applications aren't published, it's going to be difficult for folks to put that submission into the design patent application. However, they could do it if they learned about the application, they knew about the application, and they had the information necessary to make the submission. And I'll get to your question. The other thing is, though, that the time period that's a little bit different for designs than in some of the utility situations. Since design patents are never going to be published, in the statute, one of the time periods is 6 months from publication of the application or the issuance of the first action, whichever is later. As far as that's the period when you can make the submission. So since a design patent application is never published, we never hit 6 months from publication. So the trigger in a design patent application for a third-party submission, should one know about it and want to make the submission, is going to be whether or not there's a notice of allowance in the design patent application. Now, you had a question?
Oh, I was just going to ask, that'll change the Hague implementations?
Then you will be looking at that, yeah. Yeah, that's an issue that we have to face for that. Yes. Yes, ma'am.
Yes, why is it that design patent applications are not?
Because design patent applications, this happened a bunch of years ago, but design patent applications retain their term of 14 years. So it's 14 years from issuance instead of 20 years from the filing date of the application. And so that was one of the concessions when they were doing the change of term, so forth. They went into the publication. So they gave the publication, since designs they didn't make the change with it. So. Okay, so to run quickly through some of the things, the inventor's oath or declaration, some of the major things, because the AIA affects designs as well as affects utility. So these things that have changed in the utility world have also changed in the design world. So some of the significant changes in the oath of dec provisions: one, who is the applicant? who can file the application. Applicant is no longer synonymous with the inventors, so the applicant in an application can be the assignee, so it can be the corporation, it can be someone, it can be an entity that the inventors are obligated to assign their inventions to, or it can be a party that shows sufficient proprietary interest in the application. So if you're interested in what some of these mean, the sufficient proprietary interest, so forth, I take a look at the rule package for oath of declaration and the rules, and it discusses it at length. Also, that the declaration is no longer required at the time of filing or within 3 months within the time period set in the notice to file missing parts. Now, a declaration can be filed up until the payment of the issue fee as long as there is a signed application data sheet in the application, either at filing or in response to a notice to file missing parts. So you can delay that submission of the declaration, but I would recommend to folks to really think about if that's a benefit to them or not. One of the things I always say is that if you can't find your inventor before you file your application or in those first few months after you file your application, what makes you think you're going to find the inventor, a year from now when you're getting ready to pay the issue fee and you have a 3-month statutory time period to pay it? So it cannot be extended. In the utility world, people talk about, well, my claims are going to change during prosecution, et cetera, so I don't want to do that until the very end, but maybe that's not as much a consideration in design. So I'd think about really if it's to your benefit to delay the submission. Also, something that we heard from the public, we made a change so that each inventor can execute their own declaration. It doesn't have to list all the other inventors in it, and you can use this practice as long as there is a signed ADS in the application that identifies all of the inventors. So as long as we have one place, the signed ADS that gives us the entire inventive entity, each inventor can execute his or her own declaration that only names him or herself in the declaration. Also, I would really highly recommend, you've heard me say it probably 4 times, 5 times already, use a signed ADS. Use an application data sheet, sign it, submit it when you file the application. Your priority claims, your benefit claims have to be in it. You want to do that. It's a habit, something you want to get into. If you have any questions about this, take a look at our website. We have a lot of information on our website for all the different provisions under the AIA, and I strongly recommend you going to that to look at it. Next thing I'm going to talk about quickly are the fees. So some of the things we tried to do with the fees is we wanted to continue to foster innovation and make access to the patent system easy for folks. So some of the upfront costs are now below what our costs are. Our previous statutory authority was that we had to operate under a situation where we had to recover our costs for the actions that we did. Now we just have to recover our costs for the aggregate work that the office does in total. So in this case, we're able to make the upfront fee smaller so that it's easier, below our costs, so it's easier for folks to get into the process. Also, the micro entity, as we've talked about a little bit, 75% discount, and it does apply to the rocket docket cases, and I'll show you the price of that. Okay, and some of the other things, the RCEs, I just mentioned, I left it on here for folks who might be practicing also in utility, but just to remind folks that RCEs are not available in designs. I wanted to show you the price for designs now under the new fees that went into effect just this month. These are the new fees for designs. So your filing, search, and examination fees all wrapped up, about $760. Your issue fee is going to be a little over $1,000 for a total of about $1,700. Yes, sir.
Yeah, I was told in discussions that filing, search, exam fee went up significantly the last fee revision.
Yeah.
And I was told that the goal there was to shift the fees from the issue fee stage to the filing stage and not to increase them, and that after the average pendency, which is 12 months to 15 months, whatever, they're going to drop the issue fee by approximately the same amount.
Yeah, okay.
Is that
I don't know exactly that, but in the utility, they have proposed there's a new issue fee that's going to go into effect at the end of this year. So January 1, there's a new, much lower issue fee that will go into effect after that cycle's over. Yeah. So stay tuned. Interesting thing that's happened with the fees, just quickly, for appeals. So what we've done in the appeals, in case you do in one of these few cases that get appealed to the board in designs, please note that what's happened now is that there's an appeal forwarding fee. So there's no longer a filing of the brief fee, but instead it's an appeal forwarding fee. That was done mostly for cases that, because people had a lot of complaints about the fact that they were going to the board, and after they had filed their appeals, the cases were getting withdrawn, the prosecution was being reopened, so they paid for these appeals that never actually happened. And so people were very upset about that, so this has changed. But this is something that I want to just bring to your attention because it does affect designs. So there is a fee now for forwarding your appeal to the board. As I said, 75% discount for these from microentity. And so if you've got an inventor that meets the requirements of microentity, then you're looking at about a $225 fee for that. Yes, sir.
So I just want to comment in my world that the requirement of only having 4 prior patents where they make it better that were not assigned to your employer is considered kind of a joke. Because all the serious innovators and independent inventors around here have been named on lots of patents, and they're the productive ones. And so the general view among my clients is that now it's just window dressing to make it look like independent inventors were being taken care of.
Okay. Just, I just, for folks who aren't familiar, maybe haven't read much about microentity, but the issue the gentleman's speaking to is actually what's set forth in the statute. That's not our rules. It's what's set forth in the statute. So that's why I make the comment that we just, we're provided with the statute. We implement the statute. So that's why a little glib, but okay. So first amendment to file. I'm sure everybody here, especially the practitioners, no one had anything to do probably after March 16th because you did everything prior to March 16th. I actually gave a talk on March 18th in San Francisco, and everyone there seemed so relaxed, so happy. They're like, oh yeah, I came today because I got nothing to do anymore, So anyway, so with that, I'll talk about First Amendment file. So First Amendment file did a few things. First of all, it converted the U.S. system, as you may know, to a first to invent system from a first to file system. I'm sorry, first to file from our old first to invent system. The focus now under First Amendment file is the effective date of the application instead of the invention date. So we want to always, it's a new thinking under the AIA, it's the effective filing date of that application that we're considering. Also, something to keep in mind that when you're thinking about prior art and whether something is prior art to an application for these new applications filed after the 16th, you're looking through the eyes of the application that's being examined, not the piece of prior art that's being considered. So it's irrelevant when the prior art was issued or when that prior art patent you might be considering was filed or published or patented as to whether or not it's an AIA case or not. What you're doing is you're looking through the eyes of the application that's being examined, and that's the application that's being examined will dictate whether or not you're making the AIA considerations or pre-AIA considerations with respect to the piece of art that you're looking at. Also, now patents and patent application publications are prior art as of their earliest effective priority date. That's both domestic and international. We eliminated the geographic limitations of the pre-AIA with respect to sales and public use. And then commonly owned subject matter now is no longer just to obviousness, it's also to anticipation. Now, just very quickly, I want to just show you a couple of things here. This is a very rough type of concordance. It's, please don't hold me to this, but this is a slide that the office has shown where, just to give you a thought sort of about this, but you can see that the old 102A and 102B are sort of reflected in the new 102A1. And something that some design folks maybe are familiar with is the old 102D where you had the premature foreign patenting. I'm sure a lot of practitioners here maybe have dealt with that issue of, gosh, my client got rights in another country more than 6 months ago. What happens now? What can I do in the US? So forth. And 102D was a sticking point to you, and you had to be creative to get around it, so forth. And that wasn't translated, wasn't brought over into the AIA provisions. So this would have been a case, for example, if you had a case like that where you probably wanted to wait till after March 16th to file that application, and you would have gotten away from that. And then the old 102E was sort of brought into the 102A2 portions of the AIA.
Hey, Brian,
Yes.
here's a softball.
Oh, God. Here we go.
You can call me Perry. What is the single most significant provision of the AIA that applies to design patents that does not apply to utility?
What's the single most important provision of the AIA?
In other words, everything
yeah.
you said really applies to both. Is there something
Right.
unique about the AIA that
Well,
design patent practitioners need to be aware of?
I think that's why, you know, Perry, I actually looked at that when I was preparing for this presentation, and there really is a lot of overlap, even to the point where I was looking at in the oath or deck stuff, we retained some of the time periods for making, you know, your claim for priority, your claim for benefit, so forth. It's not, you're not caught up in some of the more difficult things that and consequences now that you would have under utility. So there haven't been a lot of changes, I would say, that would really impact the design patent folks, because, you know, prioritized exam, yes, it's not available, but you have the rocket docket, which is, you know, as we've seen, 8 months to conclusion of everything, which is, you know, around the times of what's happening in prioritized exam and a lot less expensive. So I don't really think it changes much in the world of folks here. I think the biggest thing that you have is the first inventor to file, and now what is prior art and what's not. So if I had to answer the question, I'd say first inventor to file is the biggest change in the fact of, but again, all that affects utility as well as design. So.
Was that the correct answer?
The answer is not.
Yeah. But see, but it's still applicable though. So it's still, it can. Understood, but again, the question was what applies to one, not the other, and it is. It isn't the odds, but it's why I mentioned it to you just briefly, but, you know, didn't go into all the detail of it. So, all right, so just to also let you know that there are some exceptions with respect to 102 under the AIA, and the exceptions are, there are some for 102A1 art, so the old like sort of 102A, 102B type art, and then there is exceptions also with respect to the 102A2 art. But I would say to you that when you're making your analysis of the art, make sure that even if you have an exception under one, that it's, for example, you have an exception under the 102B2 stuff, that it's not prior art under 102A1. So just make sure, check everything, because just because you have an exception doesn't mean you're out of the woods. Last thing is, transitional applications, we're requiring folks to give us a statement about transitional applications. It does apply to designs as well. Might not be as much of an issue for you, but basically it's the ones in the middle, so where you're straddling the fence of March 16th, there's a requirement for that. So, but if you're before March 16th, after March 16th, if you're after March 16th, you're not making a benefit claim back to before March 16th, either of those situations, you don't have to give us a statement about transition. And that's pretty much it. Again, anything with the AIA, I strongly and highly recommend that you take a look at our microsite. Our microsite's got everything on it. We've got all kinds of resources, all kinds of guidance on the site. Take a look. If not, please contact our help number or our email for any questions you might have. Thanks.
I think we're running a little late, so we're just going to go to the Hague system. So, Alan, you're up.
Just a few brief words about WIPO, World Intellectual Property Organization. And it's okay to say WIPO these days for those who remember a past Director General of the organization. WIPO is an international organization located in Geneva, Switzerland. It's a specialized agency of the United Nations. It has 185 member states, including, of course, the United States. It has basically 4 core functions: services, systems like the PCT, the Madrid system, the Hague system, for acquiring and or maintaining intellectual property rights. Development of the law through its various committees. The one that would be relevant to the subject matter today would be the Standing Committee on Trademarks, Industrial Designs, and Geographical Indications, which consists of member states that meet to discuss developments in the law, launch new treaties, things like that. Sometimes there's soft law provisions that come out of that committee as well, non-binding guidelines of indicating what the general practice is. Infrastructure is the third main category. We build collaborative networks and technical platforms to share knowledge and simplify IP transactions through our various databases, the most recent one being the Global Brands Database, which is related, of course, to trademarks. And finally, development, to build capacity in the use of IP in support of economic development in the developing countries around the world, many of which are also member states of the World Intellectual Property Organization. But with respect to the first item that I mentioned, the services, today we're going to talk about the Hague system. This is a new possibility that's on the horizon for U.S. users. It's the main treaty is the Hague Agreement for the concerning the international registration of industrial designs. It's a treaty in 3 acts: the London Act, the Hague Act, and the Geneva Act. The Geneva Act is the most modern. It's the one that was specifically negotiated with the U.S. design patent system in mind, and it is the future of the Hague system. I have some materials in the foyer. I might mention them now, 2 in particular. One, there's a little brochure, about 12 pages, that gives an overview of the system for those who don't know it. And for people who want to go right to the source, there's a little A5 publication that has the legal texts, meaning the treaties, the common regulations, and the administrative instructions that run this system. So I suggest that you grab one or the other or both of those. This slide behind me now, and I'll have to get used to turning around to look at what's behind me, is sort of the mantra of the Hague system. It sort of summarizes in words what the system is all about. The centralized acquisition, maintenance, and management of industrial design rights by filing a single international application for a single international registration in which one or more contracting parties are designated. In other words, countries in which, or intergovernmental organizations in which you seek protection for your design rights. One of the key aspects of that first statement is the maintenance and management. This distinguishes it from the Patent Cooperation Treaty and also makes it similar to some extent to the Madrid system. It's not just the acquisition, it's the subsequent life thereafter using this vehicle of an international registration. This system basically allows right holders to target national, regional, or global markets with respect to particular goods. We think it's cost effective and efficient at the front and back ends, not only at the time of filing, but also, as I mentioned, in the maintenance and management of the resulting design rights, and creates opportunities that wouldn't otherwise be available for any enterprise with a limited legal budget, be it small, medium, or large. And I can tell you that I've heard the big companies talk as much about cost, obviously, as the little companies. It seems to be a universal concern, regardless of your size. And the only thing I would add to this third, maybe sub-bullet point, is that obviously with the advent of the internet and online services, there are a lot of tools that we provide to facilitate acquiring these rights, like an electronic filing system, an e-payment system, electronic renewal, and the such. Basically what the Hague system is, I guess for those of you who may not know it, or to put it in context, it is now an alternative route into the export market. The traditional route is what you see up behind me, the direct filing. As an applicant, you go to different offices in different countries seeking protection of rights in different territories, multiple filings, in other words. The Hague system basically employing the concept of centralization, as I mentioned in the previous slide, filing a single application in one place. The International Bureau, although we'll get into that in a little more detail on the next slide, and then designating in that international application the countries in which you seek protection. Right to this. This is a flow chart for the acquisition of the rights, which I guess might be the most fundamental aspect of the system. It's animated. More things will appear on the screen in a second. But these are the three main, I guess, actors in the Hague scenario. The office of the contracting party of entitlement. That's your country. That's connection. Entitlement, I guess, is a legal term that indicates that you need a connection with a country, a contracting party, in order to file the Hague system. There are some interesting ways around that, but basically the U.S. has to be a party to the system for you to use it, except in one special circumstance. There's the International Bureau that's going to process the international application, at least with regard to formalities. And then there's the Office of the Designated Contracting Party, the place or the country in which you are seeking protection. And there can be one or more, obviously, designated contracting parties in an international application and a resulting international registration. So to start with, you have an international application, which you can file indirectly with the Office of the Contracting Party of Entitlement, in your case, the USPTO. This is one of the options you have. Please note that at the top of the chart, there is just an international application that doesn't have to be based on any pre-existing national right. This distinguishes it from the Madrid system, which some of you trademark lawyers may know requires a pre-existing basic application or basic registration before you can file an international application. That does not exist in the Hague system. You can file an international application. In fact, it can be your first filed application in terms of claiming priority in another filing elsewhere. Another ramification of this absence of the requirement of a pre-existing national right is that when you designate a contracting party, you can also self-designate your own country. This is another thing which you can't do in the Madrid system, which might raise some interesting issues in the future. I don't know if we'll get into them exactly today, but it does open some new possibilities. In addition to indirect filing, and by indirect filing I mean getting to the International Bureau by going through the USPTO, you can file, you can file directly with the International Bureau. We have an electronic filing system, which actually is quite good, I must say, and most of our applications come that way. With the United States, obviously, there will be an issue, which will come up on the screen soon, with regard to export licensing, and there are different options that you might employ or different approaches you might employ to satisfy that requirement. But nonetheless, the International Bureau, the application flows to the International Bureau either indirectly through the USPTO, will flow indirectly through the USPTO, or directly to the International Bureau itself, which will then notify by way of publication in an International Designs Bulletin contracting parties in which protection is sought. Looking at the various responsibilities of these three parties, again, the Office of Contracting Party of Entitlement, which in your case would be USPTO, may require a security clearance. And that can be, as I understand the design law in the United States, can be acquired by filing indirectly with the USPTO, or can be acquired beforehand and filing directly with WIPO, is what I expect the situation to be. As to which one you will use and why, that's not for me to say. I'm just the procedural guy. The substantive guys are out there in the audience, and the big guns from the East Coast are here, I might note. Anyway, the application is forwarded or gets to the International Bureau, where it does a formalities examination. If it passes that, it gets inscribed in an international register. There's a certificate of international registration that's issued. And as someone pointed out earlier today, the design is published in the International Designs Bulletin, providing, again, a different, I guess, an interesting couple of situations. With regard to publication, also a feature of the system, I might add in parentheses under there, is that there are three options. There's the standard time to publication, which is 6 months. It's sort of built into the system by common consensus when the treaties were adopted. But you also can request immediate publication for a shorter period of time, let's say 2 months, or there's a possibility for deferring publication up to 30 months. in the Hague system, depending on the contracting parties that you designate and what their law allows. But there is that possibility in the system. Once the International Bureau okays the formalities through its examination, the Office of the Designated Contracting Party is notified and will undertake the substantive examination with regard to the design rights. There can either be no refusal or a refusal. Now, the significance of that sort of obvious statement is that under the treaties, if a designated contracting party does not issue a refusal within a certain period of time, the designation automatically has effect as a national right. So if, for example, generally speaking, there are some exceptions, but generally speaking, it has to be done within the refusal period, which by default in the treaty is 6 months, but can be extended by any given designated contracting party to at least 12 months. So, go ahead.
Oh, I have a question. I don't know if it's really
Yes. I don't know. I can't speak to it at the moment. We're in the midst of drafting the proposed rules for it, and it would be premature for me to talk about it.
Thanks, sure. Okay, that's fair enough. I can't say anything. The U.S. has spoken. So I'm bound. So basically, this is how the structure of the system and how it works. Obviously, we don't have a lot of time. We're already over time already to go into the details of it. It's only one aspect of this panel, but it is something, again, that's on the horizon, and you know, I think you should really pay attention to it. I might by way of summation, just to put it in perspective and to not to mislead you, perhaps. This centralized filing treaty is extremely simple in concept, but much more difficult in implementation and use. I mean, and that's not surprising given what it's trying to accomplish by bridging all these disparate design protection systems around the world and give you an opportunity to centrally file and reap the obvious benefits, cost-effective benefits from centralization. It depends very much on the use of a knowledgeable design practitioner, whether legal or paralegal, in-house or outside counsel, to navigate its provisions and successfully exploit the advantages it provides. So again, I can't emphasize that enough. It's not sort of you put it in here and it comes out there and you're good to go. It takes a lot of knowledge, requirement, and thought, but it delivers results in terms of cost savings. I think the most relevant or interesting example with respect to the United States is a company called Procter & Gamble that files based on its offices in Cincinnati and was the biggest user of the system in 2011 before the U.S. joined. The reason they can do that is because this definition of entitlement, they have a connection with Switzerland through their European European headquarters, so they can file with the Swiss office as a U.S. company. This is, again, it's a very interesting idea of entitlement that was developed for the Madrid and Hague systems, but nonetheless exists. Of course, it only works for companies that are big enough to have a European headquarters in Geneva, Switzerland. Obviously, small businesses in the United States cannot take advantage of this sort of backdoor approach to the system. But I just mentioned them in particular because they use it to great effect. They were responsible for 10% of the filings in 2011. And they regularly make presentations on the money they save using the system. So I anticipate similar use by countries, other design-oriented countries in the U.S. And that's, I think, all I'm going to say now. I look to my leaders here, both to Mark and to James, if there's time for any questions. James, why don't you run the show here?
All right. Oh, I think the person back, raise your hand first.
Yeah, Asian countries and why they're not members, I guess is your question. Well, I'll start out with a story and it's something that a Japanese JPO person told me years ago. He said that Japan joined the Madrid system anticipating that the US would join right afterwards, but they didn't for 10 years. So they said they would never do that again with regard to the Hague system, that they would wait for the US to join. Well, since then, I think China would be a good reason for a country to join, let alone the United States. I mean, it's a tremendous market. India, other countries like that. But I think the momentum is starting now. In fact, we are talking with the Chinese. We are talking with the South Koreans. We are talking with the Japanese. We receive lists of questions, especially from the Japanese, all the time. So clearly, they're thinking of moving on it. The ASEAN member states have, in their action plan, committed to join the Hague system by 2015. I think that's a little ambitious. They're just getting around to joining the Madrid system by 2015, but certainly I think 2015 or soon thereafter you'll see a lot of Southeast Asians. So the system is poised to expand quite a lot in the near future, particularly into Asia. So I look forward to that greatly.
Yeah, I think we have time for one more question. You, sir?
How does the ability to register GUIs and animated GUIs under the Hague Agreement differ from the allowance rate?
It differs because it's a procedural treaty and not a substantive treaty.
But the same GUIs and animated GUIs are allowed?
Well, the provisions for the reproduction of the design are fairly broad because we have to accommodate a lot of systems, if that's your question. So we don't get to whether or not it can be a design or not. We just get to whether you have satisfied all the formalities with regard to the reproduction of the mark, whether you paid the fees, whether you've... Go ahead.
So you have comment on what fraction of the contract
I don't know. I mean, that's
I think there's actually
that's
I saw one
the easy
hand go
answer.
up, so this will be the last one. So.
How do the various patent offices get compensated for the substantive examination portion? The money is going directly to WIPO, right?
There is a fee structure, and WIPO does get a fee for its administrative services. But each country, and especially a country like the United States, which is an examining office, can set their own individual fee.
Well, do most of the contracting parties now, do they typically get less than filed directly in that country with a single application?
No, it tends to be the same. I think there are provisions in the treaty that talk about the fee can't be any more than what would be required under the national law for a direct filing, but subject to any savings by the international procedure. But as a practical matter, it seems to be fairly similar, or almost identical in most. I can't think of one where it's different. But there are several fee structures in the Hague system. One is the individual fee, which the country sets what fee it wants, and then it receives that. And WIPO is a pass-through. If the WIPO is a pass-through for that particular fee. There is another fee-sharing system for countries that aren't examining offices. That's a little more complicated, paying into a common pool and then distributing depending on how much activity actually took place in that country. But the U.S. wouldn't be involved in this second fee structure.
Well,
I would have to disagree. I mean, because you can file in a single international application, you can have 100 designs. You can file in one place, not multiple filings. As a matter of law, you don't need an attorney to file in a foreign office. You can file it indirectly here. That's not to say that you don't need to consult an attorney regarding a foreign jurisdiction, but it's not required. And then also the other aspect I mentioned, the back end, which is the maintenance and management of the resulting international registration and its bundle of national rights, to borrow a phrase from the Madrid system. I'm not a design practitioner. I'm more familiar with trademarks in terms of cost, but I know if you're doing the back end work on a trademark registration, you're talking hundreds of thousands of dollars just because you moved across the street and you have to change your name and address. You can file that centrally through the through WIPO in the Hague system and get that changed or forwarded on to each contracting party. So, yeah, you raise an interesting point. In both the Madrid and Hague, that is often a misconception. You can't just look at the front end, although I think there are more front end savings in the Hague than there are in Madrid, but there's also the back end. So, and that's why, you know, these companies get to like it. And once you develop a strong filing system or an expertise, like for example, Procter & Gamble, I don't have their information with me, but you know, I can find some slides for you that show you how much they save or how much they claim they save by using the Hague system. So, and that would be another thing. Last thing I would say about the fee. Sorry, Bart. We have a fee calculator on our website. You can plug in all the variables and find out how much it would cost. And that's why I never give average cost for filing with the Hague, because it varies so much on the countries you're going to designate, the nature of the designs, how many designs, color, black and white, all of those things. But we have a nice little fee calculator. You plug in the variables, hit calculate, and it gives you a printout of what it's going to cost administratively to file through the Hague system, and you can compare that against any other alternative you might consider.
All right. All right. Thank you, Alan. I think we're out of time, so we'll close off our panel discussion.
All right, we will take a break until 11 o'clock, and we will return to talk about scope of design patents.